there you are. Okay.
We're all good. So now I'm going to start our live stream now. So we're going to be joining the live stream, and we'll get started in about 3 minutes. So we'll be all set. So Amy, I mean, I imagine you've been really busy with these topics. There's been pretty busy, a lot of questions coming your way on the Equal Pay Act.
A lot of questions and, not a lot of answers yet because it's such a new statute. And as we'll talk about with our audience, it was something that Colorado went way out over its skis, to use a local analogy, in terms of, I would say, not really understanding the impact of what they were asking employers to do.
Mm-hmm.
And so there's a lot of confusion and a lot of like, it can't possibly mean this. And as far as we know, it does mean some of the more draconian aspects of it. So we'll see. It's funny, I've just been busy with a lot of different employment issues. Most people think that it would be COVID related, but that kind of peaked and then calmed back down. I think with the vaccinations, we'll get a lot more questions now regarding requiring people to be vaccinated before they come back into the workplace.
Oh,
so
wow.
that's the next frontier.
Huh.
is whether or not you can make that a mandatory requirement to coming back into it's okay for hospitals and other things, but whether you're going to be allowed to require people to come back into the office being vaccinated. And so far the indication is that yes, we can make that a job requirement.
Oh, wow. That's interesting. Yeah. Mm-hmm.
But what about you? I mean, are you seeing an uptick on people asking for pay audits, and are you guys going to kind of jump into that with both feet, or?
Yeah, so definitely it's we've been doing a lot more pay audits in support of this particular initiative, and frankly across the country there's been a lot of interest in pay audits. So yeah, I definitely want to get talk to you a little bit about that. But we are at the top of the hour right now, so I want to make sure that we kick things off. I know we have we want to make sure best use of everyone's time here. So welcome everyone to the Colorado Equal Pay for Equal Work Act discussion here with Amy Hartman. So I want to just give you and everyone an understanding. I know that we're online here in Zoom, but we're also multicasting across several different platforms, including Facebook and YouTube and Twitter and LinkedIn. So if you're on one of those platforms and you're not on the Zoom platform, please feel free to still put your comments and questions in the box there, and I'll make sure that we get back to answering those. But if you're on the Zoom platform here, we're live, so you can go ahead and just enter your questions in the chat box below, and we'll take those through the presentation, and we'll have a part at the end where we'll have a discussion and we can take questions there as well. And we do have the capability of and hopefully if Zoom is working right, because we did have some problems earlier, but if Zoom's working right and you would like to speak and during that Q&A section, and I can promote you to a panelist, and we can have a discussion. You can ask your questions live, or if you prefer just to do that through the chat, you can do so that way as well. So let me introduce our speaker today, Amy Hartman, and of course she's been on the People Strategy Forum. If some of you are familiar with that, she's done a lot of contributed a lot of her time through that forum and helping employers get up to speed on the different regulations and related to the COVID situation, and also there's a lot of employer law and so forth, employer employment law. So she's your go-to source there. Is there anything that you would like to introduce yourself, Amy, and tell us a little bit about your background?
No, we can sort of jump right in, Sam. I'm just happy to be involved in the presentation today and assisting HR specialists and in-house counsel with employment-related issues. It's a fraught time. with all that's going on with regard to COVID regulations and the new Equal Pay Act. And we've got lots of different things going on. So staying abreast of all of the different statutes and regulations can sometimes be pretty complicated. And you should just, everyone out there in the multiverse should just know that Sam and his team and me and my team are really ready and able to assist you with all of your HR related legal compliance issues. And so we can go ahead and jump right in to this new statute that is giving, I think, a lot of people angst. And Sam and I were talking before we went live that it's sort of my impression that there are a lot of unintended consequences for this new statute that we as employers and HR specialists are having to navigate through. So just a little bit of background, the Colorado Equal Pay for Equal Work Act went into effect in January of 2021. It's actually been kicking around, and the legislation was enacted back in 2020. So it's been on hold and ready to pounce. And so now it is fully enacted and in play. And it consists of two components. And the first is the equal pay for equal work. And the second is the equal pay transparency rule, or the EPT rules. The equal pay for equal work, let's just stay on this slide for 1 second. Equal pay for equal work is something that has been enacted in 49 out of 50 states. So that's not really anything too controversial, and is almost universal or nationwide, that we have equal pay laws, or equal pay for equal work laws. And even the equal pay transparency rules are really up and coming. We're seeing a lot of states enact different transparency rules, but they have a different connotation than the Colorado posting rule. And so we'll get to that. So while a lot of states have transparency rules, none of them go as far as the Colorado posting requirements that we are going to talk about at length in just a few minutes. So let's turn to the equal pay for equal work. Really straightforward. You cannot pay differently gender identified individuals different wage rates for substantially similar work, regardless of job title. So a couple of things to unpack there. Colorado, California, New York, I believe Massachusetts, all went a little bit farther than, or further than, just gender, and went to gender identified individuals. So again, Colorado being on the forefront with a couple of other states to include transgendered individuals, or anybody who identifies as female, identifies as male, and sort of broadening out those categories. You can't pay those gender identified individuals a different wage rate for substantially similar work. And that is regardless of job title. So we can't just change or slap different job titles on individuals and then qualify that for different wage or compensation and benefits. So adding an executive VP to some titles, as opposed to just a vice president or an SVP or an apprentice or engineer 2 versus engineer 1, when they really aren't doing different job duties, is not going to cut it. And when they say wage rate, they include the compensation and benefits. So again, pretty straightforward. But of course, there are exceptions, and one might argue, next slide, please.
Oh, just one real quick question here, Amy, as far as, when we talk about gender identity, of course, this is a kind of a new concept with a lot of employers that have, in the past few years, and so forth, of how to document and because if we don't know what a person's gender identity is, it's hard for us to put data across that and ensure that we're paying fairly, right? So what are companies doing in this space to identify gender identity and track that in their systems?
Oh, excellent question, Sam. So I think, a lot of us are seeing when we have this, signature lines for emails and things like that. How do you identify, him, her, his, or, she, her? And so I think one way is to ask employees and individuals to self-identify what they're comfortable with, what their pronoun choice is. And so self-identification really is the way that we're going there. And as we say, asking people what pronouns they prefer, how they want to be identified, and understanding that that may even change over time or over the course of employment. And just being mindful that I think in general, the promotional aspect of the statute is that people across genders, across gendered identity should be compensated the same. So that should not be a factor in that, or that should no longer be a factor. I think that, Sam and I maybe, I don't want to date Sam, I'll date myself. There used to be, a more paternalistic viewpoint of compensation and benefits. And there was definitely a feeling that it was okay to compensate sort of male or male identified employees more because they were, sort of the breadwinner, or they were the primary earner in the workplace. So really, the Colorado statute and many of these statutes that are being adopted are really almost reaching back in time and saying that if those old stereotypes remain in place in your workplace, we are now going to codify and legally remedy any of those vestiges, any of those belief systems that that somebody who is male or who is the primary worker, if you will, should be compensated at a higher rate than somebody else because, for whatever traditional stereotypes might still exist.
Great, thank you.
So, of course, there are exceptions in terms of when we can pay different rates for different work, and these are differentials that are based on any one of these factors: seniority system, a merit system, a production-based system. Geography. So again, we can pay differently in different geographies, or if we're requiring a different individual to travel overseas, or primarily their job is on the road. The factors have to be applied reasonably, and prior wage rate or history is not relied upon to justify the pay disparity. So I'm going to point to two things on this slide. One is that bottom left, the reasonable related education, training, or experience. So, I mean, I look at that, I think a lot of HR people look at that and say, wow, that would seem to really be the exception that swallows the rule here. Because obviously we're looking at resumes, and if we want to pay somebody who happens to be male a higher wage rate than a female, oftentimes we can point to, maybe a master's degree, or the person has more years of experience, or they have some specialized training. So, I don't want to say that there are ways to slide around this, overarching principle of equal pay for equal work. But that's a big, I would say, I don't want to say a loophole, but it is a big exception there that may allow employers to take advantage of that and sort of creep back into a pay differential. I don't advise it. I think that we should be looking at similar situated individuals the same, and that we should be looking at the resumes the same, and without regard to gender. But that is an exception that's there, seniority systems as well. Again, it has to be applied reasonably, and the prior wage rate or history is not relied upon. So that bottom left prong is something that's really important. We're going to get to sort of the second part of the Equal Pay Act before we get to the promotion, the posting rules, is this ban on asking about salary history. So that is something. Go to the next slide.
And one other thing,
sure.
Just another question. So a lot of times I'm just wondering, there's a lot of gray area here, and we look at these different areas. if an employer, let's say an employer gets under audit and they find that their pay is not equitable, and then the employer like will say, well, it's because of the reason, their education and so forth, and they point to one of these things on the screen here. Now, it's necessary? Isn't it necessary to have this in their policy beforehand, that they do pay differently based on location, they do pay differently based on merit? They have merit programs and ways of documenting this. Is that required?
I mean, I think that that's going to be something that any audit or the Colorado Civil Rights Division is going to look at when they're evaluating whether or not the factor that you claim that you're relying on is reasonable, and that it's not just a one-off situation. And so if we have a situation where we have somebody claiming that they were unfairly compensated, or that they were discriminated against based on their gender identity in terms of compensation, it's not going to be enough for the company to say, well, in this particular role at this particular time, we decided to look at X. So you're absolutely right, Sam. It has to be something that before we went out and looked to fill that open position or to promote that person, one person over another, that we had a seniority system in place, for example, we had a merit system in place. And that we said, although I think most job postings and most companies, again, for that reasonably related education, training, or experience, to me, that's the biggest loophole. Because I think adding a sentence to your job application or your posting that says we may take into account education, training or experience in sort of deciding on the range of compensation, which we'll see when we get to the posting rules. We are allowed to post a range of compensation, not just the salary for this job is X. Those are going to dovetail together in possibly creating an exception.
Okay. And we have another question from our audience here. And so the text says solely on one of these factors is in the text. So can they utilize more, of course, of these factors to explain the differential in pay?
Yes, I think the solely really refers to that it is the only reason that you're compensating differently is because of one of, and I should say it could be one or more of these particular factors. These are the only exceptions, even though they seem to me a little bit broad, but these are the only exceptions. And it has to be that you are making that decision based on one, I guess, and I would agree with that, the poster, one or more of these exceptions reasonably applied and without looking at prior wage rate or history.
Great.
So salary history then, which we talked about just a moment ago on the earlier slide, is something that really is gaining speed and traction across the country. So this is not something that is Colorado specific. I believe that currently there are 18 states, I can't list them all, but there are 18 states and rising that have salary history bans. And so what that means is it prohibits an employer from justifying differences in pay by pointing to differences in prior salary. And it bans employers from collecting prior salary information. So we have really two takeaways here. You want to make sure that the guidance that we're giving today on our presentation is practical for everybody out there. And so the practical takeaways here are twofold. We really need to educate hiring managers and recruiters that may be out of state or not in a state that has this requirement, that they can't collect this information, and we don't want to hear about it. So sort of earmuffs. We don't want to hear about that the candidate is looking for this particular salary and here's what they had at their past 5 jobs. So educating all of our recruiters and hiring managers that is no longer an acceptable question or line of inquiry is really important. And then obviously going and looking at our job applications, because traditional job applications oftentimes have that salary history component to them. So two quick takeaways there is educating our hiring managers and also reviewing our job applications. Mm-hmm. And then the second thing is, and we can go back to any question, but the second thing is, on the flip side, employees are free to discuss compensation information with other employees. And there is an anti-retaliation provision to the Colorado statute that says we can't punish employees for choosing voluntarily to share their salary information with their coworkers. So again, a lot of times we have in our offer letters, we have in our handbooks that salary information is confidential and that an employee can be subject to discipline if they disclose or discuss salary information. And that's a no-no now. It was before under the National Labor Relations Act, but now codified in the Colorado statute, as well as, again, many other state statutes, that we cannot retaliate against or prohibit the employees from discussing their own personal salary. Now, of course, that does not apply to like an HR professional who has access to employees' salary information as a result of their job, or anybody in accounting or payroll. So there is an exception there. You can't go around disclosing other employees' compensation, but you can't prohibit the employees from talking about their own compensation. So I think we had a question or two.
Yeah. So just the question on that is exactly what you said. I mean, you put it in the frame of HR cannot share other compensation in your discussion there, but there was a particular client that I interacted with, and what happened was their one of their employees gathered compensation information from a lot of their colleagues and then shared that compensation information along with their own across the organization. So, I mean, that's also protected? Is that correct?
I think that's a real borderline issue. I think if the employee is collecting information that all these other employees voluntarily disclosed to him or her, and then decided to sort of like put it all in one place, I think that the statute would say, well, all of these people voluntarily disclosed all of that information, and all that this individual was doing was compiling it and then posting it. I think that would be protected.
Okay. And another question on the prohibits recruiters from asking certain questions. So one thing that I've heard, a question came back to me is like, well, what if we just say, well, what is your what salary would you like to have, or what salary do you require, or they would say, or what is pay like at your company, whether the program's like, and what are the levels that are expected in your company. So what are your thoughts on that?
Well, there is an exception if the applicant volunteers their salary information or their salary requirements. So I probably would put a little bit of a nuanced twist on what you suggested, Sam, is maybe the question would be, is there anything that you would like to share with me about your salary requirements? And I think that would be a way to get at the fact that it was completely voluntary. It wasn't something that we were requiring or requesting, but we were opening up the discussion to anything that the applicant wanted to share. It reminds me quickly of a story I just heard from a colleague's daughter was changing jobs and was going to take a $10,000 pay cut. And she said, well, you should tell the new company that you're going to be getting a $10,000 pay cut and see if they have any kind of a sign-on bonus or anything. So the young woman said to the HR person exactly that. And the HR person said, well, we do have a signing bonus, but you have to request it. Are you requesting a sign-on bonus? And the young woman said, well, yes, I think I am. I am requesting a sign-on bonus. And the HR person said, okay, then you get one. So there are ways where she clearly was not offering the sign-on bonus, but she was making sure that the applicant knew that one was available should she happen to request it. So I think similarly, if you had a recruiter who was asking the applicant if there was anything they wanted to share about their salary requirements, I think that would be acceptable.
Okay, great. So we have another question here. If an employee shares their salary with one employee and that employee tells others what the employee makes, is that something that they should coach and prohibit from doing? Or if an employee is only intended, if the employee only intended that one person to know? So what are your thoughts here?
I do think that unless the first employee is giving the second employee permission, that having an internal discussion about compensation is certainly what the statute is trying to get at. It's almost out of the union organizing, and again comes out of the National Labor Relations Act, that you can't prohibit groups of employees from discussing their salaries. I do think it's one thing. It's another thing that if an employee takes that information and arguably without permission, then shares it on, that if the first employee were to complain to human resources, that wasn't the intent of the conversation. I think we would at least have a conversation with the second individual about disclosing information that was provided to you in confidence. But I would, I guess, err on the side of maybe addressing it, but also saying this is the consequence. You are free, and we as an employer can't get involved. We can't retaliate against you. So be careful how you share that information, because it may go further than just sort of the water cooler discussion.
So let's talk a little bit about retaliation. What constitutes retaliation? I mean, is it does it have to be like disciplinary action, or is it having a conversation? Could that be considered part of that threatening area? What's your thoughts there?
Well, I think that traditionally retaliation was really there was a movement, I would say probably 5 or so years ago, where companies really were cracking down on the sharing of any kind of compensation information, and that would take the guise of either discipline, a verbal warning, or even in some cases termination, because it was supposedly confidential. So I think that any employer that has that mindset that we can discipline employees for sharing their own pay or compensation range, or here's what my bonus was, we just have to get out of that mindset completely, that the employees are free to have those discussions.
Mm-hmm. Great, thank you.
So let's move on to the pay transparency rules, or the job posting requirements that are now in Colorado. And I will say from the outset, any of our participants on the call who are feeling, wow, I have friends in other states who don't know what I'm talking about, or think that this is really, it can't be as bad as I'm thinking that it is. It is as bad as you think it is in terms of what is required of Colorado employers in terms of these posting requirements, and it is unique. So for the first time, we have probably not what we want, not where we want to be. Is we are ahead of California in terms of having statutory requirements that are employee friendly. So we have leapfrogged. I mean, actually, there was a lot of discussion in the chats and in the different programs that I participated in, that said, like, wow, somebody has finally, a state has finally gone ahead of California in terms of how proactive they're being with regard to these requirements. So it's probably not a title that we really want as Colorado employers, but there you have it. So they took 2 sentences in the statute and really created kind of massive confusion. But what it reads is that an employer is required to make reasonable efforts to announce, post, or otherwise make known all opportunities for promotion to all current employees on the same calendar day and prior to making a promotion decision. So these are Colorado employees only, but we must advise them of any opportunity for promotions worldwide. Because again, they didn't really, I think through the statutory requirements. And then they added two different regulations that expanded and made it even more confusing. So we took a 2-sentence part of the statute, and we added a statement of purpose, which was 5 pages. They added the EPT, Equal Pay Transparency Rules, on November 10th, which were another 4 pages, created so much confusion that on December 20th, we got what's known as info number 9, which is another 6 pages of guidance and discussion on the rules that implemented the regulations. So if you feel like you're lost already, that is why Amy and Sam are here. Let's break this down a little bit. And the first thing is really to talk about what is a promotion.
And one more thing. I'm sorry, Amy, got a
sure,
question.
No problem.
So on related to this, we were talking, part of the posting requirements is having the salary range on the job description, right?
Mm-hmm.
And so I've had some questions come through on online where people are asking, well, what if I put we may have a tight range for our pay structure, but what if for competitive purpose, if I put a real broad range on the public job description, that's different than what our targeted pay structure is. What are your thoughts on that?
If we can just hold off on that question for about 2 more slides, we're going to get there and talk about it. And if that's okay, let's just kind of continue with the posting, the promotion part of this, and then we'll get to the bands of compensation, and we'll address that question as best we can, based on the information that we have.
Okay.
But the first concern, that people have with this statute is, what is a promotion? And a promotion is broadly defined. It includes any position opening where a current employee, qualified or not, would view the opportunity as a promotion. So I want to go through a couple of the examples here. So if we have a new customer service representative position available, or an opening, or we have we're moving somebody from a customer service representative 1 to a customer service representative 2. Well, many people in the organization would not consider that to be a promotion, but maybe the administrative assistant would. And so we have to post that position, and we have to post that customer service representative position in California, in wherever, because the administrative assistant in Colorado, if she's able to apply for that position, would consider that to be a promotion. So the statute says we don't have to post every position, but then it turns around and basically defines promotion so broadly that I really can't even think of a position that isn't a promotion or a promotional opportunity for somebody. So it really de facto requires almost every position within a company to be posted, because it's a promotional opportunity for somebody. This also includes in-seat promotions. And this was something that was fought about. I remember I told you a minute ago that we had the statute, then we had the rules, then we had the interpretation of the rules. And that was because the employers in Colorado are always allowed, both sides are always allowed to give their input before the rules are finalized. Hey, do you realize the consequence is going to be this or that? So the employers council said, hey, you can't really mean this to include in-seat promotions, where literally all you do after like 2 years and certain qualifications is you move from engineer 1 to engineer 2. And the only person who's qualified for that engineer 2 position is Sam, who has been in the engineer 1 position for 2 years. And they said, well, that's a promotion. And they specifically addressed what we call in-seat or progression promotions and said, you got to post them. So it includes new positions and new vacancies in existing positions, even includes new title and salary for an existing employee, since it would be viewed as a promotion by others. Now we can state in the posting that only qualified applicants will be considered, but we can't predetermine or self-select whom the posting should be sent to. So it's a big headache.
Yeah.
So you've got to like put these promotions out there. You've got to post them. You can say that only qualified applicants need apply or will be considered, but it doesn't prevent you from having a flood of applications from different parts of your organization for these positions. So that's the first thing. And I can pause there because we probably have some questions with regard to this.
Yeah, right. I guess to go through the scenario a little bit more in detail. So if a person is working on their competency development, working on that promotion, they've been telling their manager that they want to get promoted in that next level, and then a beginning certification training and been working towards that, the manager cannot just award that promotion. They first need to post and consider applications. And then upon considering of those other applications, then award the promotion to the best person. Is that correct?
Well, it is and it isn't. I mean, so there are exceptions if it is within 1 year and it's in the person's offer letter, that if you do these, things within 1 year, you will be sort of automatically promoted. That's an exception to this, but again, it has to be within 1 year period and has to be in their offer letter. So it's a pretty narrow exception. And there's another exception for if it is only certain, like a certain number of hours of skill. So you automatically are promoted after 600 hours of whatever. And again, just as an aside, and not meaning to be flip, but the example they gave in the regulations for that sort of automatic promotion after completing a repetitive task, a haberdasher needs to complete 100, for those of you who don't know what a haberdasher is, it's a hat maker, like really relevant to the 21st century here. A haberdasher has to complete 100 hats, and then they will be automatically promoted to haberdasher 2 or get a salary increase. That was the example they gave, literally 2021. So there you go. That's what we're dealing with. So haberdashers and in-seat promotions included in the posting requirement. Now, Sam, to your point, again, it's going to be the person who's going to get the job is the person named Sam, who's been working at the job and doing all the qualifications. We have to post it. There's not really going to be any other qualified candidate. So we do have to kind of leave it open and take a, shuffle through those other resumes. But we know that really the only person who's qualified is the person named Sam, who was an engineer 1 for, the past 18 months.
Okay. And related to that, you mentioned that in their offer letters. So what if it's listed in their personal development plan and that's their plan for promotion? That doesn't count.
No, as far as we know.
All right.
The specific example was that it had to be in their offer letter that within the first year they would be promoted or retitled or whatever if they remained employed and met certain requirements. So pretty narrow.
And does that posting, does that need to be both internal and external?
No, it only needs to be internal to the current Colorado employees.
Okay. And then for how long does it need to be posted before you can take action upon it?
A reasonable amount of time.
Okay.
a reasonable amount of time that would, obviously give the person an opportunity to apply. So I have already gotten this question, can we post it for 24 hours? And my answer is, if you were audited and you post some positions only for 24 hours and other positions for, 5 days, internal postings, I think you're sort of doing yourself a disservice, and you're going to be, kind of being too cute by half. And so I would advocate for consistency among your, with your postings, and not certain postings are 24 hours and other postings are, 3 or 5 days.
Lots of good questions there.
Yeah. So maybe we move on, and obviously we're going to try and leave time at the end for even more questions. So we recognize that, and there really aren't that many slides because we're getting to the heart of the statute now, and then we'll take more questions. But so the compensation benefits, I said I would come back around to this, is we have to post in each posting, again, for jobs that are performed in Colorado or by Colorado employees. So these are the compensation and benefits requirements for postings are for jobs that can be performed in Colorado or from Colorado. So a job that is, a CFO position in New York or an engineer position in California that is not going to be performed or really open to somebody can relocate to those places. We still have to, it's still a promotional opportunity. We still have to post it to our Colorado employees. We don't have to include compensation and benefits information in those postings. For jobs that are performed in Colorado or that can be performed remotely from Colorado, we have to provide hourly or salary compensation, a range of compensation, and a general description of all of the benefits and other compensation to be offered to the hired applicant. So salary range and general description of benefits is okay. We can pay above the range if the, of the posted range, if at the time we posted the range, it was in good faith that we thought we could get qualified applicants within that range. We can post broad ranges, but not overly broad. So we can't say, for example, that we have accountants and the salary range is from 30 to 120,000, where really we have accountant ones that are 30 to 60 and accountant two. So we can be broad, but it has to be reasonably and in good faith that we intended to pay within that range. So I hope that answered the first question. And again, we can pay above the range if we, tried to find somebody and then the requirements of the individual or skill set can, going back to the first part, require us to go above our range. We can, with regard to benefits, we can be pretty generic in our descriptions. Health insurance, we don't have to put co-pays or premium costs, that we offer PTO, but we don't have to put in the posting how many weeks or the level. So the perks can be a general description. The compensation, including bonus potential, has to be a little bit more specific or within ranges. So I'll pause there for a second.
Yeah, so I think that just one point of clarification, you said specifically if a job can be performed from Colorado. So if an employer has a location in Colorado and perhaps locations all across the globe or whatever, and if they post a remote job, they would have to follow the Colorado statute. Is that correct?
If another strange unintended consequence, you can say, if you want to avoid putting the compensation and benefits for that position that's in Europe or in California, you can actually say it can be performed remotely, but not in Colorado. Now, some people on the line may say, well, isn't that discriminating against Colorado citizens? Well, there is no such thing as sort of anti-state discrimination. And so that specific question was asked and answered in the regulations, that you can specifically say this is a remote job except for Colorado citizens. And if that is the case, then you can avoid including compensation and benefit information in that posting because it cannot be performed in Colorado or by someone in Colorado, from Colorado.
And then another question, but this, I think you're going to get through to this in another slide about confidential jobs. So if you're doing an executive search, for instance, and you plan on filling that, maybe the current incumbent doesn't know that you're going to replace them yet, and there's a situation there, right?
Yes, there are exceptions. We're 2 slides away from our exceptions, and we'll get there in a minute. So let's go to the next slide, which is the manner of posting and sort of, so in writing, by any method that reaches all employees, to all employees for whom it may be a promotion again. So that's a lot. That's basically all of your Colorado employees, because pretty much anyone might think any other job is a promotion. On the same calendar day, sufficiently in advance of the hiring or promotion decision, that employees receiving notice, have an opportunity to apply. Really important, electronic postings or intranet is fine. And so as long as we tell people, either in a handbook or elsewhere, hey, whenever we have an opening, it's going to be up on our intranet, keep an eye out for positions. We don't have to do what's called push notifications and let all of our employees know that a new job has been posted. So there's no obligation to constantly be reminding or informing our employees via emails or push notifications that we've posted a new job, as long as we have communicated to Colorado employees, hey, here is where we post all new promotional opportunities. They're on our intraweb, they're in our database, whatever it is. And so posting the, if we post them on LinkedIn, a promotional opportunity, or what could be viewed as a promotional opportunity for a Colorado employee, as long as we also post that on our intranet, or we tell employees where to look, that would satisfy the requirements. And again, we have to put the range, when the applications are due, or sort of when the position is being considered, and allowing people the opportunity to apply. We can't put things in there like only qualified applicants need apply, or only qualified applicants will be considered. And that way, if we get somebody who is completely, again, the administrative assistant who applies for the CTO job, we don't actually have to go through the motions, other than saying, okay, you are not objectively not qualified for this position. The reason that they included the transparency and allowing the promotions to be so broadly defined is the example that was given is, we may have, I'm going to stick with my administrative assistant, for example, is we may have an administrative assistant who was hired because he or she was, desperate for a job, accepted this job, but then their resume actually is that they had this history. They graduated with a degree in accounting. They have some qualifications that if we just looked at our administrative assistant on his or her face, we wouldn't know about those qualifications. But lo and behold, they actually are aware and feel like, yeah, actually I am qualified for that accounting position because my resume is such that I have the basic qualifications. I'm going to throw my hat in the ring. And the Colorado legislature said that's exactly what we're trying to get at. We're trying to get at not taking people at face value, and they may have sort of hidden talents or skills that we are not aware of. And there was an example that, again, gender-based, that women are, this is not me, this is the studies that they relied on, that women are not good at self-promoting, and that women may not sort of be more proactive at looking at open opportunities or looking at things and seeing that they might be qualified for those positions, so that this is necessary to sort of broaden out and let people know of these opportunities and let them decide for themselves whether or not they think that they might be qualified for these different positions within the organization. So any other questions on postings? We're going to move to the exceptions.
So one
Sure.
question came in about, so those individuals that are going out and doing regular college recruiting, for instance, and that are bringing people in on an entry level position at a regular, at regular clips. I mean, should they have just a consistent posting that's always out there saying that these jobs are open? We're always considering applicants.
Yes. In fact, that was specifically addressed in the regulations, that if we're constantly applying for like sales people or marketing people or data entry people, that it is enough that we advise or put in the posting that, we are regularly considering salespeople or marketing people almost on a rolling basis. And so there are specific issues that are addressed along those lines of sort of the recurring openings. But we still have to post them.
Yeah. Mm-hmm. Okay. I'm sorry. There's so many questions coming in. I'm trying to keep, I think we can move on here.
Let's move on to the exceptions. And we are going to 11. Is that right, Sam?
We have the ability to go to 11. Yes.
Okay, so we just have the exceptions and then some record keeping requirements and the legal stuff, and then we'll have plenty of time for questions. So the exceptions, I like that some of our participants were one step or 5 steps ahead of us. So yes, there are exceptions for confidential search. So confidential search could include, as one person said, that the incumbent is not aware that they are being replaced. It could be that we're opening up into a new market and the employees are not aware. So we're opening up a new store, we're opening up a new branch, we're hiring to fill those positions, but it is confidential. Confidential means that obviously there's an exception. Your finance department needs to know, your HR department needs to know. It can't, so it's there are reasonableness factors in terms of how confidential do we have to keep it. But there is this thing that once it no longer is confidential, beyond sort of the hiring group, we start reaching out to maybe potential people within the company to let them know that this position is going to be available or is available, and are they interested. The regs say that no longer is confidential, and then we have to post. So if you're going to keep it confidential and you don't want to post, you need to really keep it confidential, again, other than sort of the management team that needs to know. And this exception also applies to if we're using offsite recruiters or headhunters to try and fill a position, again, where the incumbent doesn't know that they're being removed, or we're adding a layer of management that we don't want to let the internal people know that that's available. Automatic promotion after trial period. Again, we talked a little bit about that earlier. So again, it's within 1 year. It has to be in their offer letter that it's an automatic promotion. And then temporary acting or interim hires. So 6 months or less. This is just, we need a stopgap. We're filling a position, we're promoting somebody for just an interim search, interim CEO, interim CFO. We don't have to post that, but it has to be 6 months or less that they're in that position. So those are the only 3 exceptions that are available to us at this point. And so pretty narrow. Again, not a lot of wiggle room on those exceptions. They really are trying to make this statute as broad as possible to promote transparency in the promotion process. So a little bit of record keeping requirements. Employers are required to maintain records of job descriptions and wage rate history for each employee while employed and for 2 years after the employment ends. So that is going to be used really more for the Equal Pay Act part of this, and not these promotions. This is going back to the record keeping requirements for the Equal Pay Act. So job descriptions and wage rate history for each employee while employed and for 2 years after employment ends. So that might be new for some of you. So that's something to keep in mind. And then we'll get to the legal stuff. And then we'll work our way backwards. So it's a 2-year statute of limitations for the entire Equal Pay Act, both parts of that we've been discussing. Back pay can go back 3 years. So this is very similar to when we have a misclassification of exempt or non-exempt or independent, contractor. It includes the possibility of liquidated damages, so double damages if it was intentional, equitable relief, promotion or reinstatement or a pay increase, and potentially attorney's fees. The violations for the posting requirements, which is a lot, people are really interested in, okay, so how is this going to work and how am I going to get penalized? So the fines range from $500 to $10,000 per violation, depending on sort of the severity and the scope. But it may be waived, the penalties may be waived if for good faith compliance. And so there's a safe harbor, and it's possible to avoid the liquidated damages with a good faith defense, reasonable grounds for the belief that the actions didn't violate the act. So we're doing the best that we can to post. A pay equity audit, and I'm going to let Sam jump in here in a minute, within 2 years of the alleged violation may demonstrate good faith. And if you have good faith, then getting rid of those liquidated damages or those excessive damages is really important. So a thorough and comprehensive pay audit of the workforce with specific goals of identifying and remedying unlawful pay disparities can really go a long way to minimizing the damages under both the Equal Pay Act and also on the job posting. And then becomes the question of who should conduct that pay audit. And we always raise this issue of whether it should be done under attorney-client or not. And I have my own viewpoint on that, and we can discuss that. But I encourage people, Comp Team, Sam's organization, is doing a lot of these pay audits. They've been doing them for a while before the statute came out, because a lot of organizations wanted to sort of be proactive in terms of EDI and making sure that these disparities were rooted out and changed. The one thing that I will say, whether or not you do it with legal counsel and you're trying to get attorney-client privilege, or you use something like ComTeam and you use Sam's group, is you really, and I think Sam will agree with me on this, you absolutely should not do an audit unless your board of directors and your executive team is prepared to actually do something with that information. It's like doing a sexual harassment investigation and then not being prepared or willing to take action against your, best salesperson because he's your best salesperson and we don't care how horrible he or she has been, we're not going to take action. I think that setting that stage of doing an audit and then not being prepared to sort of follow through on the recommendations from your auditor, it can be really damaging, even if it's under attorney-client privilege. So the first thing you should ask is, are we prepared to make those changes? And if you are, then I actually think that going to a comp team is the way to go. They have that expertise, and it shows that you're not trying to hide behind the privilege. But there are pros and cons to both.
Right, totally agree. I mean, and a lot of the situations that we're helping clients with is really having them understand or classify their jobs appropriately so that we can identify jobs that are comparable to one another and that should be paid in the same range. And so a lot of employers struggle in doing that proper job evaluation to be able to classify and level their jobs appropriately. And so that's a big piece. And then also, as we mentioned earlier, looking into your policy, your pay policies and your practices, making sure that those are documented appropriately to help you really have a line of defense there, because trying to come back after the fact and saying, well, it's because of X, Y, and Z that we did this, but there's no documentation is not going to help. So it's definitely good to make sure that your policies and programs and your structure is set up.
Great. Well, that is really all I have in terms of my prepared remarks on both the Equal Pay Act and the transparency posting rules. And so I think we should really open it up to questions and a dialogue, because I know that a lot of these things maybe on a slide make sense or they don't make sense at all. And I'm happy to try and elaborate.
Yeah, so we do have a ton of questions here to get through. And so I'll start with some of these, but please feel free to keep adding questions, and we'll see if we can get through all of these here. So the first question, as far as posting, you mentioned that these need to be posted internally to Colorado candidates, but if there's a job requirement and a Colorado company posts that's on the internet, that's, of course, can be accessed by internal people. Does that satisfy that statute?
As long as the internal candidates know where we post things and they have reasonable access to that. Again, I would think that most employees at most of the organizations that we're talking about and to on this call and elsewhere have access to the internet, and that's a reasonable expectation as part of their jobs, that they're going to access the internet and our intranet. So, you know, there has been a discussion, if we traditionally don't use technology like that, then it may be that we have to make separate arrangements or sort of post, more sort of postings within, a workplace, if it's a manufacturing environment or things like that. But as long as it's an area that the employees are sort of told how to access and are readily able to access, then it does satisfy it.
So I had a particular client that they chose to, they had a manufacturing environment. And so what they did is they created a kiosk in the break room where people could go in and check and have access to a computer in that environment.
Yeah, and that would be fine. So it's really, it really is sort of workplace specific, I would say.
Okay. Another question we had was if you're hiring for a particular role and you get a variety of good candidates for that particular role, and you fill that role with one candidate, and then 2 weeks down the road, you decided that we're going to need another person, and you choose from that candidate pool to bring that other person in. Do you have to do a reposting at that time before you can bring that other candidate in, or does the primary post allow for that?
I would say that because of the interpretive guidance that we've gotten has been so erring on the side of opportunity, and somebody might not have seen the first posting, that I would err on the side of conservatism and reposting.
Okay.
And no, that's not going to be popular, but and
Yes.
that is not based on, I guess the other thing I will say, Sam, and to our audience here is, please keep in mind that I will try wherever I can in answering these questions to let you know whether my answers are coming from the guidance that we've gotten so far, or whether or not I'm sort of giving my best estimate based on that guidance as to where we think the Colorado Civil Rights Department or division will go. So because the statute, just went live in January, as I've said, there are many of us who are representing employers who feel that despite the best efforts to try and narrow some of these things like the in-seat promotions, they've been very specific that those are included in the requirements. We're doing our best to sort of try and predict where these rulings may come. I will say that because it's new, because we have this good faith defense available to us, that I do believe that unless there are flagrant violations, that the Colorado Civil Rights Department in their investigations will hopefully be trying to promote the policies and educate the employers and not view it as an opportunity to be punitive and sort of engage in collecting a lot of penalties and damages. And we have seen that in the past when there have been changes to exempt or non-exempt rules or independent contractor, that there is an education process that they go through unless there is a lot of flagrant violations. So I would err on the side of trying to do your best to be compliant, to you make sure that you're documenting your efforts or your reasons for deciding not to post a particular position, or not to post it within Colorado, and we will continue to get updated. But we don't have any actual investigations, and the entity that's going to be doing this is the Colorado Civil Rights Department, which is the anti-discrimination arm of the Colorado State regulatory body, and they are pretty busy. And I don't know that they've been given any additional financial resources or bodies to address the issues that are being raised in the posting requirements. Now, with regard to equal pay, that clearly is something that I think will continue to be, plaintiffs' attorneys are going to continue to make those claims on behalf of individuals. I mean, it's a very similar legal action as gender discrimination or race or age. So I think they have that dialed in terms of how to investigate claims of equal pay discrimination. The pay transparency and the promotion is a little bit more of a wild card.
Yeah, I did have a comment that came in. A person was saying, "Hey, well, I'm seeing all these posts in Colorado without the pay range on it and so forth. Is this really being taken seriously?" And so that helps answer that question. So thank you. I imagine it's just a matter of time, as capacity comes about and this gets more traction, that it's going to be gain more teeth as it goes. Is that right?
I think that's right. And I'm hearing the same thing as the particular participant. I have a lot of clients who are saying like, well, I just looked at, blah, 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 giant company, and they're not doing this. So why should I do it? And I said, well, giant company isn't always right. They're just giant. And so I wouldn't use that as a necessary as a benchmark. But I think that people are struggling with the client compliance aspect of it. But I wouldn't use the fact that a large corporation that maybe a household brand name is not including these in their postings as evidence. And it could be, again, that they are including the compensation information in their internal postings, which you don't have access to.
Right. Now, the other thing, as far as the record keeping requirements, I mean, you mentioned that we need to keep certain materials, job descriptions, and so forth in the employee file for a period of 2 years. Now, I just want to clarify: is there a requirement? Of course, that's the job description at that particular time the employee was in the position. Is that
right?
Correct? Yes.
Yeah.
There can be many updates, and so we just need to make sure that we're looking at the actual one. So just keeping a repository of the job title is not enough.
Right. So the job description that they had for the position that they're filling, and then their compensation history.
Okay.
Again, seems easier on paper than in actuality. And I will say, gosh, I feel bad. I'm not bashing the state, but I am going to continue to repeat, maybe to make people feel better, that there are a lot of unintended consequences for this pay transparency. I don't know many employers that actually kept job descriptions in a person's personnel file. I mean, obviously you kept their salary range, that's, and it's, either online or in our HRIS system, but their job description, it's just not, a lot of these things are additional requirements for our employers and our HR staff that I don't know if they just didn't think,
Yeah.
or they didn't understand that this is not currently the ordinary course of business.
Right. And I know from when I bring on new clients, I mean, there's only a small percentage that has really full built out up to date job descriptions in place.
Right, exactly.
Yeah, I think the majority of employers are usually on the lagging side of that, and also their job descriptions aren't consistent, and many times from employee to employee, and they usually are writing these on the fly as they're thinking about a particular candidate or need in place, and so that can be another issue.
Yeah, I agree.
Yeah. So let's see. In going through some of these questions, some of them may be restated questions of what you've answered before, but I want to bring those up because they're still top of mind. One is, can an employee request salaries or all the salaries for all employees from HR? So can they write HR
No.
and send me all of,
No.
or
No, salary employees are free to discuss their own salary information with other employees, but they are not free to request that information from human resources. And human resources can and should continue to maintain the confidentiality of all salary information at all times, other than for the particular individual who is asking.
Okay. And this is another question that's kind of come up a couple times. So I want to ask it again so everybody can benefit from the answer. So is there a required amount of time that a posting must stay up? 24 hours, 48 hours, 1 week? Is there any best practice that you're seeing?
There is not. The only requirement is that it's a reasonable amount of time to allow the person to apply for the position. So you can't post it and say, oh, we filled it last week, or post it and say, oh, sorry, we didn't see your application because we closed, the posting and made the hiring decision the next day. So I would think that we can have some inconsistency if it's, sort of an emergency situation. But I think that to the extent that we already have any kind of baseline within the organization for how long we have been posting, to deviate from that now because of the new regulation, I think would maybe be an example of not acting in good faith. So remember, you've got that good faith defense, and you don't want to, sort of jeopardize that by, not keeping a posting up for a reasonable amount of time. So 72 hours, I would think that probably would be, about a minimum to allow people to see it, to react to it, and to, submit their name and their application.
Mm-hmm. So here's another one, and I know this is highly related to another question, but in companies that have step programs, so define pay programs where they're at a certain level, and then maybe after another year or 2 years, they go up directly to the next level based on tenure, or perhaps the step program says, oh, okay, after you obtain this certification, you automatically get promoted to this next level. Since that's a company-wide program, does it need to be documented as an open position?
Yes.
It does.
Again, the employers' organizations fought hard for this one, and it was specifically rejected as an exception. And so I emphasize that because it's not something that is an unknown. We have asked, and we have been given the answer in this case. And so I will reiterate again that the only exception is this narrowly, it's within the first year of employment, it's in your offer letter, you'll automatically be promoted from X to Y, after you've worked here for 1,500 hours or whatever. That's the only in-seat progression, promotion that is accepted from the posting requirement. So even if somebody is going from, a junior whatever position to a senior whatever position, so it's only a title change for that individual. The response back was, well, somebody else could consider that to be a promotion. They may or may not be qualified. They need to be notified of it. They need to be allowed to apply and have that opportunity. Again, only if they're qualified. Again, as I said, they're not going to be qualified. The only person who's qualified is Sam, who is the junior accountant who is going to senior accountant because he's been a junior accountant for 2 years. Nobody else could be qualified. The only person who's qualified is junior accountant named Sam. And it came back specifically, got a post.
Okay. Another piece here is if there's a person that is there an obligation to notify people that apply for a position that are not qualified for that position? And is that a requirement?
There's, it's funny is there's nothing in the statute or regulations regarding going back to your, how to go back to your applicants or informing people that they didn't get a position. So it's a great question. It's an unknown as to how we communicate to applicants that they were not considered or that they were not eligible, qualified. And so I would say that we would follow our normal practice, which is it may be that you can apply, but we're not going to necessarily get back to every person, or however we handle even external applications, but there's nothing in the statute, the regulations, or the guidance that talks about how we communicate our decision to the people who are not selected.
Okay. Now, another question here. Do all of these regulations apply to organization that is using an outside recruiting or search firm?
Yes, we can't, unless there's a confidentiality component to using the outside search firm. But if we're using an outside search firm, but we also are letting internal employees, they're aware that we're looking to fill this position, then it would be applied. The only exception is the confidentiality component of it.
Okay. Here's another question. So if you have a person that's filling into a role as an interim, let's say interim CFO or whatever it may be, and then that there may be a search going on, but if that person is doing a great job, can you just automatically keep them in the role?
No.
So you have to.
I mean, you can de facto. Again, it's going to be that we pretty much know that we've selected that person. Same thing with the in-seat progressions, but we have to be transparent in allowing people to know that permanent CFO position is being filled and an opportunity to apply.
Okay. Well, I have worked through all the questions
all right
so far. So if anybody, this is your last call for questions. If you would like to put those in there, we can take those. So we'll give a few more minutes, but I just want to say thank you once again, Amy. I mean, having you on these on the People Strategy Forum, as well as these special events, have just so helpful and to the community out there. So I just want to say thank you.
Well, I love doing it, Sam, and I really love partnering with CompTeam. And maybe as we're waiting to see if any more questions come in, I think it may serve everybody who's still on the call is to really circle back to that pay audit practice. Again, it does serve a very good function in terms of that good faith defense. And they don't necessarily have to be, incredibly expensive. Sam's organization has this dialed in and can do this for you. I think that the attorney-client privilege, again, a lot of people say, well, I'm going to have my lawyer do it, so that way I don't have to disclose it if there's legal action. Again, if you really come at it as you're using it to act in good faith and to comply, and you're ready, willing, and able to make the changes that are being suggested, maybe not all of them, then I would err on the side of going to, a firm with expertise, and this is what they do for a living, and it can be efficient, and getting those audits done and sort of making sure, Sam, as you talked about, most of the clients that I work with, that you work with, job descriptions are so far on the bottom of the list of like things that we are trying to get our arms around and tackle. And external organizations can be a huge bonus for you guys to take advantage of that and take it off of HR's plate, because templates are available, and getting it right can take you a long way to compliance in a lot of these areas. Because at the same time that you're doing those job descriptions, working with comp team or working with me, is you're also looking at exempt versus non-exempt. You're looking at Equal Pay Act. You're looking at whether or not you've got a gazillion independent contractors that I swear are not independent contractors. And so we can tackle a lot of things all sort of in one bundle, I would say.
Yes, and that's what I tell a lot of my clients, is that they shouldn't be thinking about the Colorado Equal Pay Act as a one-off thing, or oh, I got to do this for the Colorado Equal Pay Act. No, really, you should be thinking about this as building it into your overall HR process, your overall compensation administration process, and improving your operations in the organization. A lot of what is laid out here to comply with this particular act is just normal things that companies should be doing on a regular basis, an annual basis, such as defining their jobs, making sure that employees know how they can move from level 1 to level 2, or have different internal mobility opportunities. This helps with retention and giving your employees the ability to have choice. It communicates your open positions and makes people feel like there's opportunity there, that they have the opportunity to grow. That helps with motivation and engagement. And so and other pieces can be defined as far as career pathing and taking that extra step to helping people move through their career in the organization, so that makes them feel like that the company cares about them. These are things that should be really part of every organization. The other piece, as far as pay, the proper categorization of your jobs and doing a pay study on an annual basis, looking at surveys to ensure that you're paying within the competitive range, will help you attract employees and retain your current staff much more greatly. As we all know, turnover in any organization is extremely costly. We can document some of these costs directly, and then some of those costs are opportunity costs. The ones that we can document it directly is the cost of having somebody to go out and recruit and to bring in that other organization. Those other opportunity costs are the business interruption that when a person leaves your organization, or you have a lawsuit, and the bad press you get from that. I mean, it's just not worth it. So it's best to have these just good practices in place around your HR and compensation that you're maintaining year over year, and you're creating a great place to work for your people, and a place where they can grow and you can grow as a company.
Yeah, I couldn't agree more. I do have one question actually for the audience. And that is something that, as a HR attorney, but not an, HR practitioner, I'm getting a lot of anxiety and a lot of pushback in terms of posting compensation ranges and benefits, in the postings. And I'm wondering why that is. I mean, it's an honest question for our audience, is why is it that would be, that I have clients that are literally saying, well, I'm just not going to post positions in Colorado. I'm so against including the compensation and benefit ranges that are required under the statute that I'm going to do everything I can to avoid having to do it. And I guess I'm a little bit curious as to why there is that resistance to, if we're allowed to do a range and we're trying to attract people, why wouldn't we want to include that information? So I'll just throw that out to our audience if anybody wants to jump in the chat and respond, and Sam can shout it out to us. But that's been a question that's sort of been on my mind.
Yeah, one of the things that I hear about that a lot is that a lot of companies simply don't have their house in order. You know, they're like, it's like bringing people over to your house when your house is dirty or something like that. They're afraid of exposing all the pieces that should be fixed. And so that's one piece. We're having some coming in right now. Another is because of competitive reasons.
Okay.
That they're afraid that their competitor down the street is going to understand what they're paying for a particular role, and then pay higher and to attract those candidates. Let's see. And another is the leadership.
The current employees, I see that's been raised with me a couple of times, that they don't want the current employees to know what they're going out into the market with for new hires. And that goes back to your point, Sam, though, that is something that it needs to be fixed, because if we are, again, Equal Pay Act, this position, these new statutes, but if you're creating this environment where there's this mistrust, and again, you have the salary history ban on confidentiality, your current employees are going to learn what your new hires are making. And so again, to your point, Sam, this is an opportunity to sort of like clean up your own house and get your house in order. But I hear that people might not be ready to do that, and they want to do that on a voluntary basis and not be required to do it.
Yes, I had that. A lot of companies have been focused on what certain surveys are telling them as far as what their annual merit increase budget should be, and year after year it comes out as 3%, 4%, right around there, right? And then recruiting is shouting back, we can't hire anybody for this particular job because that job's pay rate is growing faster than 3 or 4%. And so the current incumbents in that role are falling behind to market. And so that's why a pay study is necessary on a regular basis to ensure that we identify those and correct that.
Oh, good. Well, I see a lot of the chats are around sort of not being prepared to have difficult conversations, managers not wanting to. So, well, this is very helpful for me, because it's sort of intuitively, from a legal standpoint, I was like, why is this so difficult? And I needed to get my head around sort of what the internal politics are. So thank you, audience.
Yes. Yes, that manager training is one big hole in a lot of organizations. I hear this time and time again, whether it's performance ratings or our managers are not having good discussions with their employees about development or about performance or about pay. And so, training your managers is critical, making sure that there's programs around manager development to help put them in place. And I also would say that it's important to think about management as a particular skill set. A lot of companies go in, they say, oh, he's our best salesperson, so we got to promote him to manager. No, you don't.
No.
No, you don't. It doesn't mean he's going to be a good manager just because he's a great salesperson.
That's
you
right.
might, so it's like make sure managers, that's a specific skill set. And so it's not just a promotional opportunity.
I agree 100%. All right. Well, do we have any last questions, or we can sort of wrap up?
Yeah, we are coming towards the top of the hour here. So I want to take this to a close, and we can go ahead, and if there's any other questions, please feel free to contact me, sam@compteam.net, and I'll see if we can get those answered for you. And but once again, I want to just say thank you to Amy, for your time and your wisdom here. So thank you so much.
All right. Well, everybody have a great rest of your day. And if you have any other questions for me, I can be reached at amy@hartmanhrlaw.com. Thanks again, Sam.
Great. Thank you. All right. Have a good afternoon. Bye now.